Woohoo, am I live? Hello, everybody. And now that disappeared on me. Okay, I'm back. Jax West from Stephen Avery Project SAP for Stephen Avery Project. Because I think I posted something before. People always confuse when I post something SAP. MAM Gossip and Justice with Jax. Today, while I was at work, I got an email from KZ with her latest filing. And this one should just be because what um, the state said that her filing that we just read a month ago or whatever was too long, had too many words or whatever, and she's had to shorten it. So that's what this one is. It is 45 pages. Let me give you a link that you could go watch it or read it for yourself if you would like. Hopefully that works for you. Um, so there won't be anything new in this because it's just a shortened thing of what we read before, but I figured we'll just read it again and go through this and talk about the case. Are we ready? I don't know where Bryce is yet. Bryce told me to wait for him, that Bryce was coming. Bryce, are you here? Um, no, there's table of authorities at the beginning of this. All right, so we're actually starting reading on page 5 of 45. Issues presented. 1. Whether the Circuit Court improperly imposed a burden on Mr. Avery to conclusively prove the Denny motive element in order to satisfy the materiality prongs of State versus Edmonds and Brady versus Maryland. The Circuit Court answered no. 2. Whether the Circuit Court erred when it did not correctly apply State versus Denny to Mr. Avery's potential third party suspect evidence. The Circuit Court answered no. 3. Whether the Circuit Court erroneously exercised its discretion in denying Mr. Avery an evidentiary hearing because its factual findings are unsupported by the evidence. The Circuit Court answered no. Statement on oral argument and publication. Pursuant to Wisconsin statute whatever, appellant does not request oral argument. A publication is warranted because the case is of interest to the public. Introduction. Mr. Avery appeals the Circuit Court's denial of his amended third post-conviction motion because the opinion erroneously relies upon false facts and misapplies the law in denying Mr. Avery's request for an evidentiary hearing. The Circuit Court misinterprets State versus Denny as requiring conclusive proof of motive to satisfy the materiality requirement of State versus Edmonds. It further erroneously requires the alleged third party suspect to have the necessary skills to manipulate evidence in a manner that would implicate the defendant to satisfy the opportunity prong of Denny. The Circuit Court concludes Bobby is the killer, by the way. Bobby's possession of Ms. Halbach's car does not directly connect him to her murder or the framing of Mr. Avery because, quote, Bobby could have been in possession of the car that night, ... to help hide evidence to protect, and now this is italicized, the two individuals, done italicized, directly linked by forensic evidence to this murder and convicted of the crime, end quote. And then there's a footnote that says citations to the record on appeal appear with the document number before the colon. Oh, we don't care about that. Furthermore, the Circuit Court relies upon Brendan Dassey's confession, stating that the confession specifically implicated Mr. Avery in this crime to support its decision denying Mr. Avery relief. Brendan Dassey's confession was not admitted as evidence in Mr. Avery's trial, and the circuit court should know this basic fact. Second, the circuit court mistakenly believes Brendan was linked to the crime forensically. He was not. Another basic fact that has escaped detection by the circuit court. I still need to sit down with a lawyer, or maybe I should just email Kathleen. Nobody's ever been able to explain to me why, how, whatever, two people can be prosecuted for the same crime, but two totally different ways. There is no Brendan in Stephen's case. What you have on Stephen is all just the doctored evidence, the planted evidence. That's all they have on Stephen. For Brendan, they have his obviously coerced confession. But there's no Brendan confession in Stephen's case. Now we're on page 7 of 45. The circuit court proposes a completely irrational justification to explain Bobby's actions in moving Ms. Halbach's vehicle onto the Avery property. Bobby was trying to help his uncle by hiding evidence. In the circuit court's nonsensical conclusion, because these actions could be seen as an effort by Bobby to help Mr. Avery, Bobby cannot be considered a valid Denny suspect. The circuit court fails to explain why, if Bobby was simply lending a helping hand to his homicidal uncle, he would then become the state's primary eyewitness against Mr. Avery, or why all of the forensic evidence used to convict Mr. Avery is not discovered until Bobby moves Ms. Halbach's vehicle onto the Avery property. Yeah, it's so ridiculous because, all right, let's just say, since the state likes to do bizarro scenarios, let's say Brendan was the lead in this case, the lead defendant. And thinking that Brendan was the one that everything they're saying Stephen did, that Brendan did. But then somebody called and said they saw Stephen driving the car or pushing the car onto the property. They absolutely would have gone after Stephen for that. But because it's Bobby, the only thing they have, their star witness saying that he saw Teresa Halbach walking towards Stephen's trailer, they buried it. I'm not understanding. Well, I am understanding because they just need to keep Stephen in prison, and they don't care about facts. They don't care about science. They just, Stephen did it, so we won't look at anything else. Oh, it's frustrating. All right. Next section's titled Statement of the Case and Procedural History. This case began in early November 2005 with the disappearance of Teresa Halbach, a 25-year-old professional photographer. On November 5, 2005, volunteer searchers... I love how they don't say Teresa Halbach's family members. Teresa Halbach's cousin found Ms. Halbach's Toyota RAV4 on the 40-acre site of Avery's Auto Salvage. After finding her RAV4, law enforcement searched the Avery property and, over the next 4 months, discovered evidence including burned bone fragments in and around a burn pit with DNA matching Ms. Halbach's. No. Isn't it that there has never been any Teresa Halbach DNA and that it matched the maternal line in the Halbach family, right? Okay, let me go back. Mr. Avery's and Ms. Halbach's blood in the RAV4, remnants of electronic devices and a camera, the same models as Ms. Halbach's, in a burn barrel, Ms. Halbach's RAV4 key in Mr. Avery's bedroom with Mr. Avery's DNA on it, but not hers. Mr. Avery's DNA on the hood latch of the RAV4, deposited, the state later claimed, by his sweaty hands, and a bullet in Mr. Avery's garage containing Ms. Halbach's DNA. During the trial, Bobby was the state's primary eyewitness against Mr. Avery. According to Bobby, Ms. Halbach was last seen walking towards Mr. Avery's trailer on October 31, 2005. The state used Bobby's testimony to establish that Ms. Halbach never left the Avery property alive. If Bobby had told the truth that he saw Ms. Halbach leave the property that day, Mr. Avery would never have been charged with her murder pursuant to the state's theory, which did not involve Mr. Avery leaving his property. According to the state, Mr. Avery discharged his firearm into Ms. Halbach's head in his garage and burned her body for hours in his burn pit after putting her vehicle by the crusher. On March 18, 2007, Mr. Avery was convicted of first-degree intentional homicide, contrary to Wisconsin statute whatever, and felon in possession of a firearm, contrary to Wisconsin statute whatever. The jury found Mr. Avery not guilty of mutilation of a corpse. There has been members from that jury who has said the reason the not guilty of mutilation of a corpse, because, all right, if you're finding Stephen guilty and somebody was burned in a fire, obviously then you should also think that there was mutilation of a corpse. But there were people who found reasonable doubt and were not going to vote guilty. We're not voting guilty. And you had two people in the jury that are affiliated with the Manitowoc Sheriff's Department. You had Carl Wardman, who was a community service officer for the Manitowoc Sheriff's Department, and whose son was a deputy that you can see in a picture with Stephen. And then there was another person who was married to a deputy. So you already, Stephen, there's no way Stephen was going to be found not guilty because you had those two people planted on the jury. So at best, all Stephen could get is a hung jury. But there were some people on that jury that said there was reasonable doubt. They wanted to say not guilty. And the compromise was not guilty on mutilation of a corpse. And what those people thought is that would trigger a mistrial, because how would that make sense that you could be found guilty of this, but then not guilty of burning the body? And it just, so they thought that was a way around this, and it didn't work. So, that is that. Okay. Okay, I'm trying to find where I was. On October 11, 2019, Mr. Avery appealed the circuit court's denial of his second post-conviction motion and its supplements. During the pendency of the appeal, a new witness, Mr. Thomas Sawinski, contacted Mr. Avery's current post-conviction counsel in December of 2020. On April 10, 2021, Mr. Sawinski provided an affidavit to Mr. Avery's current post-conviction counsel, stating that he was a motor route driver for Gannett Newspapers, Inc., and delivered papers to the Avery salvage yard in the early morning hours of November 5, 2005. Prior to delivering the newspapers, he turned on to the Avery property and witnessed two individuals, Bobby Dassey and an unidentified older male with a long beard, suspiciously pushing a dark blue RAV4 down Avery Road towards the junkyard. The RAV4 did not have its lights on. Mr. Sawinski drove past and delivered newspapers to the Avery mailbox and then turned around and drove back towards the exit. When he reached the RAV4 still there, Bobby attempted to step in front of his car to block him from leaving. Mr. Sawinski came within 5 feet of Bobby and swerved into a shallow ditch to escape Bobby and exit. After Mr. Sawinski learned that Ms. Halbach's car was found later in the day on November 5, 2005, he immediately contacted the Manitowoc Sheriff's Office. On April 12, 2021, Mr. Avery filed a motion for remand and stay of appeal to this court containing Mr. Sawinski's original affidavit. On July 28, 2021, this court issued a per curiam opinion, I don't know if I said that word right, upholding the circuit court's summary denial of Mr. Avery's claims raised in his motion and 2 supplemental motions. However, this court instructed the following, quote, "As discussed below, we are not addressing Avery's most recent filing to this court." See our discussion of motion number 6, which seeks to directly connect Dassey to Halbach's murder. If Avery wishes to raise that claim, he will need to bring a new Wisconsin statute motion. That motion would need to survive both Escalano-Naranjo scrutiny and be found to have merit, in which case, now this is underlined, the evidence presented might supply the missing direct connection, done underline. In that event, the Valley CD evidence might become relevant to showing Dassey's motive and might bear on whether Dassey is or should have been a viable Denny suspect, end quote. Regarding certain claims, such as the alleged Brady violation pertaining to the witness, Mr. Kevin Romlo reporting to law enforcement his observation of Ms. Halbach's RAV4 in the turnaround on State Highway 47 on November 3 and 4 of 2005. This court made no determination as to whether it would be barred. Page 10. On August 16, 2022, Mr. Avery filed his 3rd motion. His motion set forth the newly discovered evidence of Bobby seen in possession of Ms. Halbach's vehicle after her disappearance. Affidavits from 2 witnesses, Mr. Kevin Romlo and Mr. Thomas Barash, corroborate Mr. Sawinski's observations. Mr. Romlo observed Ms. Halbach's RAV4 parked at the turnaround at State Highway 147 and the East Twin River Bridge on November 3 and 4, 2005. He reported this to a Manitowoc Sheriff's deputy on November 4, 2005. Sometime between 2 a.m. on November 5, Mr. Barash observed Bobby driving the RAV4 in the area of Highway 147 and County Road Q in Manitowoc County. In his motion, Mr. Avery also raised Brady claims. He attached supporting documents showing Mr. Sawinski's phone call to the Manitowoc Sheriff's Office was suppressed by the state. Mr. Sawinski's ex-girlfriend, whom he was dating on November 5, 2005, and Mr. Sawinski both identified Mr. Sawinski's voice on a recording of a phone call made to the Manitowoc Sheriff's Office on November 6, 2005 at 10:28 p.m. Pertaining to Mr. Avery's Brady claim concerning Mr. Romlo's observations, no law enforcement report was ever generated memorializing Mr. Romlo's conversation with the Manitowoc Sheriff's deputy. The Circuit Court denied Mr. Avery's motion on August 22, 2023. Mr. Avery filed a timely notice of appeal on August 24, 2023. This appeal follows. Where am I? Sorry. Okay. Argument 1. Whether the Circuit Court improperly imposed a burden on Mr. Avery to conclusively prove the Denny motive element in order to satisfy the materiality prongs of State v. Edmonds and Brady v. Maryland. This Circuit Court misapplied State v. Edmonds by requiring Mr. Avery to conclusively establish Bobby's motive to murder Ms. Halbach in his motion on its face, that's italicized, in order to satisfy the materiality requirement of Edmonds. A. Standard of review. An appellate court reviews a circuit court's determination as to whether a defendant has established his or her right to a new trial based on newly discovered evidence for an erroneous exercise of discretion. Oh, somebody just sent a message saying no comments can be made on your live. I think a thing that was set on this live is that you have to be a follower of the page in order to make comments. Only profiles and oh wait, sorry. Okay, sorry. Hopefully that changes it. It was set up to be only pages that I follow can make comments. So go ahead and try your comment now. Can I get back to now? Hold on, trying to, okay. So now you can see if, okay, there you go. Sorry, it was on only people I follow could post. So now you all should be able to follow. And thank you for letting me know that. And comment away now. That was my bad. Where was I? All right, I'm at A, standard of review. An appellate court reviews the circuit court's determination as to whether a defendant, oh, I read that part. All right, so I'm at B, burden of proof. On a motion for post-conviction relief pursuant to Wisconsin statute, whatever, a defendant has the burden of proof. To obtain an evidentiary hearing on a motion for a new trial on the basis of newly discovered evidence, somebody's saying it's still not letting them comment. All right, hopefully you'll be able to get in and make your comment. Sorry, I'm getting distracted by things on here. By messages I'm getting. All right. Sorry, squirrel. To obtain an evidentiary hearing on a motion, Natalie still can't comment either. Maybe you have to go out and go back in. I don't know. Or slap it. All right. To obtain an evidentiary hearing on a motion for a new trial on the basis of newly discovered evidence, the defendant first, quote, must show specific facts that are sufficient by clear and convincing proof, unquote. Christopher says Facebook Lives are having technical difficulties. Oh, hold on, let me. All across the board at the moment. Oh, issues are not on our end. Thank you, Christopher. Okay, I'm in the quote. Must show specific facts that are sufficient by clear and convincing proof, unquote, to demonstrate that, quote, 1, the evidence was discovered after conviction. 2, the defendant was not negligent in seeking the evidence. 3, the evidence is material to an issue in the case. And 4, the evidence is not merely cumulative, unquote. C, argument. The circuit court found that Mr. Avery satisfied all the elements required to admit his newly discovered evidence, the Sawinski evidence, but for the materiality requirement of Edmonds. It erroneously imposed a new Denny requirement that Mr. Avery must establish that Bobby had a motive by conclusive evidence to commit the murder of Ms. Halbach to meet the Edmonds materiality requirement. Specifically, it stated, quote, hey, Cindy. A review of the record and the defendant's argument revealed that he has failed to satisfy the third standard of the Edmonds test as well as the motive element of the Denny test. With respect to the Edmonds test, the defendant argued that the evidence offered was material to an issue in the case because it established that there was a viable third-party suspect that could have committed the murder of Ms. Halbach. And such evidence was never presented to the jury for consideration, undermining confidence in the verdict reached. In order to meet that burden, the defendant had to prove that the evidence also met the standard set forth in Denny to be admissible as proof of a third-party suspect. The defendant failed to establish that Bobby had the requisite motive to commit the murder of Ms. Halbach, unquote. It really aggravates me that to prosecute Stephen, you don't have to have a motive, but for there to be any other possible suspect, you have to prove their motive and that there has to be a viable motive. You're supposed to be about wanting justice, right? And wanting whoever did this crime is punished. Now, I get that you don't want somebody in court to just be throwing all these wacky scenarios out there, and saying Bozo the Clown did it and this did it, just to clog things up. So there has to be some rationale to it. And then you also don't want a defendant to, victimize the family of the victim. And just then start suggesting everybody in their family. I get that there has to be some method to the madness, but how is it any more likely that Stephen would do it than Bobby? Because there's nothing in Stephen's past that says he's going to murder some random chick. According to the circuit court, Mr. Avery would have to satisfy two tests for it to admit the affidavit of Sawinski into evidence. The circuit court improperly found the materiality of Mr. Avery's newly discovered evidence is exclusively contingent upon its satisfaction of the Denny test for admissibility. In determining that Mr. Avery's new evidence could only be material to the issue of a potential third-party suspect, it completely ignored its inherent materiality to other material issues in Mr. Avery's case. In Mr. Avery's third motion for post-conviction relief, he argued, the Sawinski evidence is material to several issues in Mr. Avery's case. It is material for establishing Mr. Avery's defense, that is, that a third party committed the crime against Ms. Halbach. Additionally, the Sawinski evidence is material to the evidence in the RAV4 being planted by Bobby, including Mr. Avery's blood and DNA. The RAV4 also contained the Halbach vehicle key and Ms. Halbach's electronic devices, which were discovered in Mr. Avery's bedroom and burn barrel, respectively. Further, the Sawinski evidence is material to impeach Bobby's trial testimony that Ms. Halbach never left the Avery property and that she was last seen walking towards Mr. Avery's trailer. I mean, doesn't it make sense that everybody's kind of stating like it's fact that Bobby had the RAV4? So then everything that's associated with the RAV4 is now linked to Bobby. Any evidence in that RAV4, Bobby now had the opportunity to touch. So her day planner, her key, because now remember, the key that was planted in Stephen's bedroom is the valet key, is the spare key. It is not the key that she used every day. So Bobby had that key. So blood is found in that car that is allegedly Stephen's. Stephen didn't do anything, but Bobby had the car. So therefore, it's reasonable to think then that Bobby put the blood there. I personally don't think Bobby did that. I still think that was planted by Manitowoc. I think Manitowoc did the blood and the key and the bullet. All right, let's go back. The new evidence that Bobby had possession of Ms. Halbach's vehicle is highly material for evaluating the reliability of the forensic evidence used against Mr. Avery, which all happened to be derived from Ms. Halbach's vehicle. Crucially, it is also material to the credibility of the state's key eyewitness against Mr. Avery, Bobby himself. This court pointed out in its July 28, 2021 opinion, quote, the state's theory was that Avery shot Ms. Halbach in the head in his garage and threw her in the cargo area. Sorry, I think my husband's home from work, so my dogs are going to bark. Yes, he is. And threw her in the cargo area of the RAV4. He then burned the electronics and camera, cremated Halbach in a burn pit, transferred the remains to a burn barrel, and hid the RAV4 until he could crush it in the Avery car crusher, unquote. Mr. Avery's new evidence shows that the vehicle left the Avery property and was in possession of a third party. Additionally, it debunks the state's theory against Mr. Avery that he kept the RAV4 on the Avery property by the crusher so he could crush it immediately. Which also, I'm a broken record. I know every time I read these things or we talk about anything, I go over these same things over and over. But maybe there's new people that haven't heard me say these rants. But Stephen went to Crivets that weekend. So if Stephen is just waiting for everybody to be gone so he could crush something without anybody in the family seeing it, he would do it that weekend when everybody's going to Crivets. Yet he went. And if Bobby or Brendan did anything with Stephen, he would have stayed back too. Stephen would have made him, like they're claiming that Stephen made him rape her and stab her and this and that and all the other. Then Stephen would have made Brendan stay back with him and help him in cleanup. Yet both of them went to Crivets. Yet Bobby did not. The evidence of Bobby's possession of Ms. Halbach's vehicle is material because it shows that Bobby had possession of the forensic evidence used to convict Mr. Avery. The vehicle was the crime scene by virtue of having all of the relevant forensic evidence in it, including Ms. Halbach's blood. The Sawinski evidence establishes that Bobby, the state's primary eyewitness, had control of the crime scene for a period of time. Despite police searches preceding the discovery of Ms. Halbach's vehicle, her electronic devices and key were not found until after it was found. The only logical conclusion to explain this is that all the items remained in her vehicle and were then moved by whoever had possession of her vehicle. If a third-party suspect had possession of Ms. Halbach's vehicle, numerous areas of reasonable doubt arise, such as that the forensic evidence in the vehicle is tainted by the third party having control of it before, that's italicized, before it was discovered by law enforcement on the Avery property. This would have created reasonable doubt in the jurors' minds, particularly since the state's primary eyewitness was the one in possession of the vehicle. Mr. Avery's new evidence also presents an alternative theory for the source of the forensic evidence used against Mr. Avery. State v. Edmonds is the leading case on newly discovered evidence. In Edmonds, the defendant was convicted of the death of an infant she was caring for. The defendant filed a motion for a new trial over a decade after her trial and offered medical testimony showing a shift in mainstream medical opinion as to the cause of the types of injuries the infant suffered. The court found the evidence was material to an issue in the case because the main issue at trial was the cause of the infant's injuries, and the new medical testimony presented an alternate theory for the source of those injuries. Here, applying Edmonds, Mr. Avery's new evidence is material to a key issue in Mr. Avery's case because Mr. Avery's new evidence that Bobby had possession of Ms. Halbach's vehicle after her disappearance presents an alternative theory for the source of the evidence used to convict Mr. Avery. The Sawinski evidence is additionally material because it completely calls into question the credibility of the state's key witness, Bobby's testimony, which allowed the state to argue that Mr. Avery had exclusive control of Ms. Halbach and her vehicle, containing all of the forensic evidence, and that this evidence was not tainted by any third party. During its closing argument, the state emphasized the importance of Bobby's testimony, vouching for his credibility. Quote, again, an eyewitness without any bias. It is a, that's how they worded it, a instead of an. It is a individual that deserves to be given a lot of credit, unquote. With the new Sawinski evidence, as well as Mr. Romlow's affidavit, the state could not possibly have presented an unbiased Bobby to establish Miss Halbach never left the property in her vehicle and that she was last seen walking towards Mr. Avery's trailer. Its critical eyewitness link to obtaining Mr. Avery's conviction. Bobby was the only witness whose testimony the jury requested to, quote, read or hear a transcript of, unquote. Clearly, by Bobby possessing the vehicle, there is a reasonable likelihood it would have affected the judgment of the jury in that. I hear my husband walking behind me. Where was I? There's a reasonable likelihood it would have affected the judgment of the jury in that Bobby would have emerged as a much more likely suspect in Ms. Halbach's murder than his recently released, wrongfully convicted uncle. Contrary to the state's representations to the jury, Bobby was biased and deserved no credit for his fabricated testimony. In regard to a motion for a new trial, a reasonable doubt as to a defendant's guilt has been found to exist when the credibility of a witness critical to the state's case is completely called into question by newly discovered evidence. State versus Wilson. Quote, a new trial is required if the false testimony could, in any reasonable likelihood, have affected the judgment of the jury, unquote. In State versus Plude, the defendant presented newly discovered evidence that an expert witness lied about his credentials. The Supreme Court of Wisconsin found that because, quote, the expert witness's testimony was a critical link in the state's case, his quasi-medical expert testimony creates a reasonable probability that the jury hearing of his false testimony about his credentials would have had a reasonable doubt as to Plude's guilt, unquote. Notably, in Justice Annette Ziegler's concurrence, she found the new allegations that the expert witness misrepresented his credentials created a serious question, quote, as to whether the interests of justice were served, unquote. Mr. Avery presents a stronger case about the materiality of his newly discovered evidence because it shows Bobby committed perjury in his trial testimony, and it taints all of the forensic evidence used against Mr. Avery, which resulted in his conviction. In this court's July 28, 2021 opinion, this court did not believe the impeachment of Bobby was material because it found significant forensic evidence linking Mr. Avery to the crime. However, the Sawinski affidavit establishes Bobby's possession of the Halbach vehicle, which taints the forensic evidence used against Mr. Avery. This strengthens the materiality of the impeachment against Bobby. Now we're on page 17 of 45. In his motion, Mr. Avery satisfied Edmonds. Once the four criteria of newly discovered evidence have been established, The court looks to whether a reasonable probability exists that a different result would be reached in a trial. The reasonable probability factor need not be established by clear and convincing evidence, as it contains its own burden of proof. With regard to a motion for a new trial, the correct legal standard when applying the, quote, reasonable probability of a different outcome, end quote, criteria is whether there is a reasonable probability that a jury, looking at both the old and the new evidence, would have a reasonable doubt as to a defendant's guilt. Quote, a court reviewing newly discovered evidence should consider whether a jury would find that the newly discovered evidence had a sufficient impact on other evidence presented at trial that a jury would have a reasonable doubt to the defendant's guilt, unquote. Hi, Bryce. The circuit court, again, failed to analyze Mr. Avery's evidence under the proper test because of its improper requirement that Mr. Avery satisfy the Denny motive prong in order to show materiality of his evidence, even for purposes of Brady. It did not dispute that the prosecution suppressed the audio recording of Mr. Sawinski's call. Rather, it disputed the materiality and favorability of the evidence to find that Mr. Avery failed to establish a Brady violation with respect to the Sawinski evidence. Rather than making the required finding of no reasonable probability that a jury hearing Mr. Avery's new evidence could have a reasonable doubt as to Mr. Avery's guilt, the circuit court improperly engaged in weighing the evidence of the violent porn found on the Bobby Dassey, computer and concluded that it does not conclusively show that it was solely acquired by Bobby on the computer. I love that they tried to say that even if the original jury knew that Sawinski had called right away and reported what he saw, that wouldn't change the jury's decision. You don't know that. And that's pretty huge evidence, in my opinion. Now remember, this guy called, there was no... did Netflix even exist? Or at that time? Maybe Netflix at that time was when you could just get the DVD, in the red packaging that got mailed to you. But, in, what was this? Was this 2005? He contacted right away on the vehicle. And they suppressed it. And never turned it over to Stephen's original attorneys. And they asked for everything. I'm sorry. Don't give me they didn't ask for this specifically. You have to turn that stuff over. And you chose not to. And you buried it. So it's pretty major evidence, and any jury that is impartial and not people that are affiliated with the Manitowoc Sheriff's Department would at the very least have reasonable doubt. But you took that away. Section 2. Whether the circuit court erred when it did not correctly apply State v. Denny to Mr. Avery's potential third-party suspect evidence. In his motion, Mr. Avery presented evidence implicating his constitutional right to present a defense that a potential third party committed the murder of Ms. Halbach. However, the circuit court did not correctly apply Denny to the admissibility of his evidence. It erroneously imposed a substantial certainty requirement upon it and misapplied Denny in its evaluation of whether it satisfied the Denny elements of motive, opportunity, and direct connection. A. Standard of review. This court generally reviews a trial court's decision to admit or exclude evidence under an erroneous exercise of discretion standard. However, when a defendant's constitutional right to present a defense is implicated by the exclusion of evidence, the decision not to admit the evidence presents a question of constitutional fact that this court reviews de novo. B. Burden of proof. On a motion for post-conviction relief pursuant to section whatever, the defendant must show his entitlement to relief by clear and convincing evidence. C. Argument. Denny governs the admissibility of potential third-party perpetrator evidence in Wisconsin. Denny requires a showing that, quote, there must be a legitimate tendency that the third person could have committed the crime, end quote. A legitimate tendency is demonstrated where the defendant can establish 1. Motive, 2. Opportunity to commit the charged crime, and 3. Provide, quote, some evidence to directly connect a third person to the crime charged, which is not remote in time, place, or circumstances, end quote. In its opinion, the Circuit Court acknowledged the standard for evaluating admissibility of evidence of a potential third-party suspect is set forth in Denny. However, rather than applying the Denny standard, it applied a stricter standard Wisconsin does not follow. In Denny, the Court of Appeals rejected the standard set forth by the California Supreme Court in People v. Green. Specifically, hold on, pause please so I can make sure this isn't something I have to... Okay, nothing I have to address on here, but I'll look later. Specifically, the Denny court disagreed with, quote, the Green Court's conclusion that such evidence must be substantial, unquote, stating, quote, we perceive this to be too strict a standard for the admissibility of such evidence and conflicts with our Supreme Court's pronouncements on the fundamental standards of relevancy, unquote. The Denny court clarified, quote, relevant evidence means evidence having any tendency to make the existence of any fact that is of consequence to the determination of the action more probable or less probable than it would be without the evidence. This rule does not say that the evidence must tend to prove a fact in a substantial is italicized, way. Unquote. Rather than requiring any level of substantial certainty, Denny adopted the standard set forth in Alexander versus United States. There, the Supreme Court fashioned the legitimate tendency test, where the standard of evaluating the evidence is that it must show a legitimate tendency that the third party could have committed the crime. In adopting the Supreme Court's test, okay, now a friend messaged me. I'll have to get back to him. Sorry. Denny elaborated, quote, we believe that to show legitimate tendency, and now this is underlined, a defendant should not be required to establish the guilt of third persons with that degree of certainty requisite to sustain a conviction in order for this type of evidence to be admitted. The Denny court differentiated between evidence which supports a legitimate tendency and, quote, evidence that simply affords a possible ground of suspicion against another person, unquote, which is merely evidence, quote, tending to show that hundreds of other persons had some motive or animus against the deceased, unquote. Unlike the inadmissible type of evidence Denny describes, Mr. Avery's evidence is very specific to Bobby and establishes a direct connection between Bobby and the crime. Hundreds of other persons did not have possession of Ms. Halbach's vehicle and have photographs of young, mutilated females on the computer of which they were the primary user. Denny states, quote, as long as motive and opportunity have been shown, and as long as there is also some is italicized, some evidence to directly connect a third person to the crime charged, which is not remote in time, place, or circumstances, the evidence should be admissible, unquote. Where Mr. Avery has proffered evidence that Bobby had possession of Ms. Halbach's vehicle after she went missing, had most likely been conducting computer searches relevant to her murder, and was on Avery property before and after her disappearance, no reasonable trier of fact correctly applying the law would find that Mr. Avery has not established some is italicized again, some price evidence directly connecting Bobby to the crime charged. 1. The circuit court erroneously evaluated the motive, opportunity, and direct connection elements of Denny. As this court pointed out in its opinion previously, evidence in support of Denny must be viewed in the aggregate. Rather than viewing Mr. Avery's evidence in the aggregate, the circuit court required Mr. Avery to present conclusive proof to satisfy each prong individually. However, quote, each piece of a defendant's proffered evidence need not individually satisfy all three prongs of the Denny test, unquote. Right, Sherry. Further, the Wisconsin Supreme Court has determined that the strength and proof of one prong, quote, may affect the evaluation of the other prongs, unquote. The circuit court completely ignored these well-established principles of law in evaluating the motive, opportunity, and direct connection elements of Denny. 2. Motive elements of Denny. In Mr. Avery's motion, he alleged the motive attributed to Bobby for Ms. Halbach's murder could have been sexual and provided evidence supporting this, namely suppressed evidence from a computer that was in Bobby's bedroom, according to his brother Blaine. Bobby was the primary user of this computer. Bobby lied to police about its location, claiming it was in the living room, but crime scene footage showed it was in his bedroom. The computer was examined and revealed searches relevant to Ms. Halbach's murder occurring during times in which the state has been unable to rule Bobby out as having conducted them. The state argued that other members of the Dassey household could have conducted them, a supposition that may or may not be true, but no other member of the Dassey household was spotted by an eyewitness with Ms. Halbach's vehicle shortly after her disappearance. Bobby's possession of the vehicle, with all of the forensic evidence used to convict his uncle, combined with the violent pornographic searches on the computer in his bedroom, of which he is the primary user, elevate him to a level of a Denny third-party suspect. The circuit court spent 12 pages of its 31-page opinion improperly weighing Mr. Avery's motive evidence, contrary to the law on motive. The issue is whether the pornographic searches on the Dassey's computer are relevant is italicized, to motive, and now this is italicized, regardless of the weight. In its opinion, the circuit court noted, quote, the state further disputes the defendant's conclusions that law enforcement considered pornography or sexual assault as a motive for the murder in this matter, unquote. However, this point is completely refuted by the record. On March 10, 2006, the state filed an amended information against Mr. Avery, adding the charge of sexual assault, among others. Mr. Avery's trailer and his computer were searched extensively for pornography, and none was found. Detective Veely was asked to generate a report of Mr. Avery's computer. Based on his report, no apparent searches of pornographic and or sexual images were made, and no websites with apparent sexual and or pornographic images were accessed. In further search for evidence to support a sexual assault motive, the Dassey computer was seized by law enforcement on April 21, 2006. In the affidavit for search warrant for Dassey computer, Special Agent Tom Fassbender attested, quote, your affiant believes that said computer may contain images, records, and messages which may be relevant to the investigation into the homicide of Teresa Halbach. Your affidavit further believes that information contained on said computer, and now this is italicized, may include evidence of the crimes of homicide, mutilating a corpse, and sexual assault, unquote. Let me pause for a second there. Why did the state finally take Bobby Dassey's computer on April 21, 2006? Now remember, Teresa Halbach went missing around Halloween of 2005. So why all these months later do they finally take it? Well, because Stephen, who is in custody, says on the phone or in lawyer meetings, I can't remember, but he's telling his attorneys to look at Bobby's computer. And because they're listening, they then go get the computer because Stephen had been telling his attorneys to get that computer. They didn't do it. They didn't listen to him, but the state did and went and grabbed that computer. The circuit court incorrectly relied upon the state's misrepresentations that the investigation was not focused on a sexual motive. Law enforcement made great efforts to extract all the pornography from the Dassey computer and even went so far as having Detective Veely conduct specific word searches, now this is italicized, related to the murder, in an effort to connect the searches to the murder. Detective Veely searched the words that he believed were directly related to Ms. Halbach's murder, generated 2,632 search results, including Bobby, 2,083, stab, 32, throat, 2, bullet, 10, DNA, 3, fire, 51, gas, 50, RAV, 74, gun, 75, handcuff, 2, bondage, 3, blood, 1, tire, 2, journal, 106. Now go ahead and put yourself in somebody else's shoes, or if they found this on Stephen's computer, it would have been used against him. But because it's found on Bobby's computer, it doesn't mean anything. It's not the droids you're looking for. In the context of Ms. Halbach's murder, all these terms are relevant. 2 bullets from a gun pierced her skull. There was a fire ignited by gas and tires which burned her body. She bled in her vehicle, so she may have been stabbed. Her DNA was found on a bullet, and she did keep a journal. Mr. Avery's blood was in the RAV4. Veely's CD contains the state's recovered pornography images relevant to her murder. On the CD, Detective Veely refined 14,099 images on 7 DVDs and recovered 1,625 violent pornography images, now this is italicized, that had been deleted. Mr. Avery has been unable to get an affidavit from Bobby admitting he conducted the searches, or someone from the Dassey household stating they saw Bobby performing them, which the circuit court seems to require. Bobby did not volunteer for a forensic or psychological examination by Mr. Avery's experts, as the circuit court also suggests is required. However, Brendan Dassey was arrested on March 1, 2006, and can be eliminated from a majority of the searches. Brian Dassey, Brian spelled wrong, was interviewed and stated that he did live in the Dassey trailer and did not know anything about the computer. Blaine Dassey, who was living there, denied ever doing a single pornography search on the computer. Bobby was the only Dassey household member who admitted that he may have watched porn on the computer. Importantly, Bobby cannot be eliminated by the state from any is italicized, from any of the pornographic searches, especially the ones conducted prior to and very close in time to Ms. Halbach's murder. And he is the only family member who had unexplained scratches on his back on November 9, 2005, which have been identified by Mr. Avery's forensic pathologist expert as caused by human fingernails. And the only family member seen by witnesses with Ms. Halbach's vehicle after her disappearance. The circuit court erroneously concluded the searches done after Ms. Halbach's murder have no weight. Conduct of a suspected person after the crime is a legitimate subject for consideration as bearing upon the probability of his guilt. Motive can manifest itself after the crime when the perpetrator is reliving and fantasizing about the crime. It is highly significant that the searches for deceased, mutilated young women began after, italicized, not before the murder and mutilation of Ms. Halbach. The searches after the murder coincide with the fact that a young woman was murdered and mutilated. The searches before the murder coincide with thousands of images of young women engaging in sexual activity, many unwillingly, and corroborate a sexual assault motive. The circuit court also completely ignored Mr. Avery's evidence of Dassey computer deletions, which infers a consciousness of guilt. There were 8 periods of deletions on the computer, correlating with Ms. Halbach's visits to the property. The deletions cannot simply be dismissed as mere coincidences. It is highly significant in any investigation if there is an attempt to delete or destroy records. Where the appellate court found, quote, the defendant's consciousness of guilt was also evidenced as he told the victim to delete text messages the two had exchanged from another case, unquote. The circuit court misconstrued the holding in Dressler versus McCautry by adopting the state's argument that pornographic images must be a mirror image of the crime or they have no relevance. The court in Dressler made no such ruling and held, quote, the pictures depicting violence were offered to prove Dressler's fascination with death and mutilation, and this trait is italicized, in undeniably probative of a motive, intent, or plan to commit a vicious murder, unquote. Likewise, here, most of the Dassey computer pornography consists of images depicting violence, even race car accidents, showing a fascination with death and mutilation. And this trait is again italicized, of the Dassey pornographic consumer is, quote, undeniably probative of motive, intent, or plan to commit a vicious murder, unquote. Mr. Avery provided the circuit court with specific searches on the Dassey computer of terms such as, quote, someone who was shot, unquote, and, quote, gun to head, unquote. There were 8 searches prior to Ms. Halbach's murder on 9/17/05 for skeleton and a live skeleton. I don't even know what a live skeleton is. After Ms. Halbach was reported missing, there were 6 searches for girl guts, 15 searches for girl hurt, and 2 searches for seeing bones, hot girls. These mirror the fate of someone hurt, shot in the head, mutilated, and burned into skeletal remains, which is a total amount of information known about Ms. Halbach's fate. Contrary to the circuit court's view, the proper standard does not require Mr. Avery establish his motive evidence with absolute certainty. This level of certainty has never been required by any Wisconsin court to satisfy the motive element of Denny or any element of the Denny analysis for that matter. Under the motive prong, the court simply must question whether, quote, the alleged third-party perpetrator had a plausible reason to commit the crime, unquote. Mr. Avery's third-party motive evidence is relevant regardless of the weight assigned to it by the circuit court. This is precisely the reason this court found that if Mr. Avery's new direct connection evidence survives Escalano Naranjo scrutiny and has merit, the motive evidence found in the Veli CD, quote, might become relevant, that's italicized, relevant, to showing Bobby's motive, and might bear on whether Bobby is or should have been a viable Denny suspect, unquote. Mr. Avery offered his motive evidence in conjunction with evidence of Bobby's opportunity and direct connection to Ms. Halbach's murder and framing of Mr. Avery. Evidence of motive that would be admissible against a third party, were the third party, the defendant, is admissible when offered by a defendant in conjunction with evidence of that third party's opportunity and direct connection. In rehashing the weight of Mr. Avery's prior motive evidence contained on the Veli CD, which this court already assessed was not sufficient in and of itself, but could be relevant if Mr. Avery could also show Bobby's direct connection, and the footnote on that said the court stated, quote, the evidence presented might supply the missing direct connection, unquote. The circuit court evaluated the CD evidence in isolation contrary to this court's prior directive. Mr. Avery's powerful direct connection evidence certainly affects the evaluation of the other prongs because it provides evidence supporting all three prongs. For example, even if the motive of Ms. Halbach's murder was not sexual as law enforcement believed, the Sawinski evidence offers evidence that the motive could have been a robbery. And there's a footnote on that, so let me scroll to the footnote. Accepting the Sawinski evidence is true. There is now proof that Ms. Halbach's vehicle and the items within the vehicle were stolen. Many things were missing from Ms. Halbach's RAV4 that should have been present, such as Ms. Halbach's purse, wallet, and money she received that day. The motive for her murder may have been a theft by Bobby and her vehicle and the items within it. Interesting. Back up. Wisconsin cases discussing the motive element of their Denny analysis show that the standard for fulfilling it is not overly burdensome, especially when there is strong evidence of a third party's direct connection to the crime. For example, blah, 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 talking about another case. I'm just skipping the other cases. Sorry, because these things can be really long and we don't need to hear the other cases stuff on what happened in there. We just care about Stephen's case. All right, 3, opportunity element of Denny. In regard to the Denny opportunity element, the circuit court found, quote, even if the defendant had met the burden with respect to the motive of the Denny test, he has not met the burden with respect to the element of opportunity, unquote. Undisputedly, Bobby was on the Avery family property when Ms. Halbach was, and before and after she was reported missing. Normally, even proximity to the murder is sufficient to show opportunity. However, the circuit court improperly imposed a burden on Mr. Avery to prove Bobby had the skills, contacts, tools, time, and or other means necessary to have committed the crime and staged the scene in order to satisfy the opportunity element of Denny. In State versus Wilson, for its requirement that Mr. Avery prove this. However, this principle came from a Kansas Court of Appeals case the state cited in its brief, State versus Kreider. The Kansas case, Kreider, is completely inopposite. In Kreider, the defendant, we don't care about this. Or we care, but I'm just not going to read all of it. Yay, Debbie can finally comment. Likewise, the facts of Wilson are completely distinguishable to Mr. Avery's case. In Wilson, multiple eyewitnesses identified the defendant as the shooter. The defense's theory was that an unidentified hitman was hired by the man in the car with the victim, and the hitman shot the victim. Blah, blah, blah. Sorry, I'm just skipping the other cases. Okay. The circuit court erroneously reasoned that pursuant to Wilson, Mr. Avery must prove Bobby had the, quote, scientific knowledge to recognize the significance of each piece of forensic evidence supposedly planted by him, let alone establish that he had the skill to plant the evidence in a way that would stand up to scientific scrutiny by professional crime scene analysts, unquote. This is not the standard for showing a third party framed the defendant. Evidence that the third party had access to the items used in the frame ups is sufficient pursuant to Wilson. Yes, Bryce, you commented too. The circuit court imposed upon Mr. Avery a standard for satisfying the opportunity element of Denny that has never before been applied in any Wisconsin case. Okay, now they're talking about another case. I'm skipping that. The facts of Volbrecht are similar to those in Mr. Avery's case, as both defendants were convicted based largely on circumstantial evidence. I'm not reading that case. The state took issue with the opportunity prong of Denny being fulfilled, noting the third party lived 30 miles from where the victim was found and killed the other victim. Oh, that's another case again. In Mr. Avery's case, the opportunity element has already been decided. According to the trial court, trial defense counsel established Bobby had the opportunity to commit Ms. Halbach's murder because of his presence on the property at the time Ms. Halbach was there. The Sawinski evidence greatly strengthens Mr. Avery's evidence of Bobby's opportunity to commit Ms. Halbach's murder because it shows Bobby was in possession of her vehicle where her murder likely occurred. He had access to Ms. Halbach's vehicle and all the evidence used to convict Mr. Avery of her murder. Correctly applying Wilson, Mr. Avery has not only shown Bobby's opportunity because of his proximity to the murder, but also because he had access to the items used in the frame-up. The defense's theory of a third party's involvement will guide the relevance analysis of opportunity evidence in a Denny case. Rather than accepting this, the circuit court found that Bobby needed some kind of expert scientific knowledge to plant evidence. There is no scientific knowledge necessary to know that planting someone's blood in the vehicle of a woman that went missing is incriminating. Common sense suffices to make this deduction. The circuit court did not explain what special skills it took to shoot Ms. Halbach in the head that Bobby lacked. All that was required was to pull the trigger. Bobby was a skilled deer hunter with a .22 rifle, who had obviously pulled many triggers. For planting blood, the only skill required is using a wet sponge to remove Mr. Avery's blood from his sink and dripping 1 to 2 milliliters into the RAV4 and applying it to the dashboard with a household item such as a Q-tip. Mr. Avery told law enforcement in a recorded interview that his finger, which had been cut open prior to October 31, 2005, re-bled on November 3, 2005, and dripped blood in his bathroom sink and on the bathroom floor. Mr. Avery told law enforcement and his trial defense counsel that as he was leaving his property on November 3, 2005, and exiting onto Highway 147, he observed taillights of a vehicle close to his trailer. He told trial defense counsel he noticed the blood had been removed from his sink when he entered the bathroom early in the morning on November 4, 2005. The bullet fragment found on Mr. Avery's property simply had to be rubbed in Ms. Halbach's blood or on her skin cells, both of which her murderer had access to, before her body was burned. This court determined, quote, the state did not argue that this specific bullet entered Halbach's skull or killed her, unquote, and there were no bone fragments on the bullet. It is undisputed that there were bullets all over Mr. Avery's property from Raleigh Johnson shooting gopher holes with his .22 rifle, as well as Jody Sikowski firing it. This was the gun that fired the bullet found on Mr. Avery's garage floor with Ms. Halbach's DNA on it. No skill was required to plant the electronic devices in Mr. Avery's burn barrel. The fact that there were burn barrels on the Dassey property, four, one of which contained human bones, shows the Dasseys, including Bobby, were proficient in burning material in their burn barrels. Part of the circuit court's certainty of Mr. Avery's guilt is based on another factual error. It's believed that all of Ms. Halbach's remains were found in the Avery burn barrel. They were found in a Dassey burn barrel. Dr. Eisenberg claimed that when she opened the container of bones from the Dassey burn barrel, she got a, quote, waft of flammable liquid or fluid, unquote, but did not smell burned rubber from tires, which the state claimed was the accelerant Mr. Avery used. This suggests Ms. Halbach's body was burned in a Dassey burn barrel and dumped in Mr. Avery's fire pit. Common sense suggests that Mr. Avery would not have been planting evidence to incriminate himself. The circuit court erroneously stated that Mr. Avery argued that Bobby planted the key to the RAV4 in Mr. Avery's trailer between November 3 and November 5. There was no such argument. Bobby would have had the key when he planted the vehicle on November 5 because it was locked when it was discovered. So whoever left it on the Avery property necessarily had the key and locked it. Now we're on page 36 of 45. Bobby had access to Mr. Avery's unlocked trailer from early Saturday morning, November 5, until shortly before noon when the vehicle was located and the Avery property was secured by law enforcement. Mr. Avery and his mother left for their Crivets cottage early Saturday morning. Per the circuit court criteria, Mr. Avery was even less qualified to commit the murder than Bobby. He was less educated than Bobby, never having graduated from high school. He was less skilled because he never held a job because of his wrongful conviction, whereas Bobby was employed as a third shift worker at a furniture factory. During all the years Mr. Avery was incarcerated for his first wrongful conviction, Bobby had been honing his skills in stalking, hunting, burning, and dismembering game. Further, the circuit court erroneously presupposed the forensic evidence against Mr. Avery stood up to scientific scrutiny in Mr. Avery's trial. Mr. Avery's defense team never presented the required experts to attack it. Mr. Avery, in his second post-conviction motion, presented voluminous evidence from numerous experts that the forensic evidence used to convict Mr. Avery was vulnerable to being discredited had the defense presented experts such as DNA, trace, blood spatter, fire, forensic pathologists, and ballistics experts. This court determined, quote, certainly these conclusions tend to support Avery's general theory that he was framed and their presentation may have been useful at trial, unquote, but concluded that Mr. Avery's experts' evidence failed to show, quote, how its introduction at trial could reasonably have led to a different outcome, unquote. Pause. If you were on Stephen's jury and you're watching this, and I understand if you want to remain private, please message me. I would love to talk to you. You could private message Stephen Avery Project right here. You can email me at officialstephenaveryproject@gmail.com or justicewithjax@gmail.com, whichever is easier for you to remember. I would love to talk to members of Stephen's jury. And I will not say who you are. Please reach out to me. Mr. Avery previously presented an affidavit stating that he noticed his toothbrush was missing in the law enforcement photos taken from the bathroom in his trailer. In regard to the hood latch swab, Mr. Avery is not abandoning his theory that the illegally collected groin swabs taken from him on November 9 after his arrest on a gun charge were substituted for the hood latch swabs when they were delivered to the Wisconsin Crime Laboratory by investigator Liegert, who signed Deputy Hawkins' name instead of his own. However, for purposes of demonstrating Bobby had the skill to plant DNA on both the hood latch and Ms. Halbach's key, Mr. Avery asserts that Mr. Avery's toothbrush could have been rubbed on both. Bobby had access to Mr. Avery's trailer where his toothbrush resided before disappearing. Any teenager watching an episode of Forensic Files could learn how to plant DNA. Certainly, the DNA searches on the Dassey computer bolster the assertion that DNA information was readily available. 4. Direct connection element of Denny. No bright lines can be drawn as to what constitutes a third party's direct connection to a crime. Rather, circuit courts must assess the proffered evidence in conjunction, that's bolded, with all other evidence to determine whether, under the totality of the circumstances, the evidence suggests is bolded. It's hard to hear me, Melissa? Can somebody else tell me if I'm hard to hear? Suggests that a third-party perpetrator, and this is underlined, actually committed the crime. In its opinion, the circuit court argued, quote, the Sawinski affidavit, taken as true for the purpose of this motion, directly links Bobby to possession of the victim's vehicle. However, possession of the vehicle does not directly link Bobby to the homicide itself, unquote. Then it highlighted, quote, Mr. Sawinski's affidavit does not mention seeing Bobby with the key to the victim's car, unquote. Thank you, John and Janet. Ignoring the fact that when her vehicle was found by law enforcement and volunteer searchers, it was locked. No worries, Melissa. Clearly, Bobby had the key to the vehicle. In State versus Williams, blah, blah, blah. Okay, I'm not going to talk about another case again. Applying this common sense, non-technical approach, the Sawinski evidence provides the direct connection. That is, Bobby being witnessed in possession of Ms. Halbach's vehicle, to Bobby having committed the murder of Ms. Halbach and planting the evidence to frame Mr. Avery. Rather than recognizing the significance of the evidence of Bobby having possession of, and thus access to, Ms. Halbach's vehicle, the circuit court required Mr. Sawinski to witness Bobby in possession of the electronics. However, a reasonable inference can easily be made that because they had not yet been found by law enforcement when Bobby was seen with Ms. Halbach's vehicle, they were still inside the vehicle and he planted them in Mr. Avery's burn barrel. Oh, and there's a footnote here. Mr. Avery realizes this case existed 2 months before it was found to not have precedential value. However, it is noteworthy for employing a common sense approach that possession of a murder victim's stolen car means the thieves probably committed the murder. Hey, Brenna. Okay, now talking about another case. Blah, blah, blah. If the same reasoning were applied to Mr. Avery's case, the circuit court would have found far stronger evidence of a direct connection to allow the defense to present Bobby as a potential third-party suspect pursuant to Denny. At bare minimum, the Sawinski evidence connects Bobby to Ms. Halbach's murder in all the same ways the hearsay evidence did to the third party in another case. 1. It establishes Bobby lied to investigators about his whereabouts during times relevant to Ms. Halbach's murder, noting, of course, the exact time of Ms. Halbach's murder is unknown. 2. Like Mass, who was observed carrying a paper bag after the murder, which the Wisconsin Supreme Court found material, Bobby was seen with the victim's vehicle after Ms. Halbach's murder. And 3, the evidence certainly put Bobby in close proximity to where the homicide is alleged to have occurred, and that combined with evidence showing that Bobby, according to his own testimony, was one of the last people to see Ms. Halbach alive, would have satisfied Denny had the circuit court applied only the reasoning in the other case. 3. Whether the circuit court hold on. I know what you'll probably say and know you did a rebuttal, but was wondering if you could comment at the end on your overall thoughts of convicting a murderer. Recently watched it and just curious on your thoughts. Brenna, I did live videos after I watched every episode, and then I also have written summaries as well, where all my thoughts are on convicting a murderer. I can't remember everything at this point that I said, but basically it's all a crock of shit, and I have so much that I countered as I watched it and stuff was fresh in my mind. So go into the videos here on Stephen Avery Project and watch those recaps I did of watching it, and then you'll know. But those didn't prove anything. Okay, where was I? So we're on section 3. Whether the circuit court erroneously exercised its discretion in denying Mr. Avery an evidentiary hearing because its factual findings are unsupported by the evidence. This court will find an erroneous exercise of discretion if the circuit court's factual findings are unsupported by the evidence. The circuit court's egregious factual errors should result in a reversal of its decision. In order to dismiss Mr. Avery's third-party motive evidence, the circuit court argued, quote, only a small number of searches were conducted prior to the murder of Ms. Halbach. No physical evidence directly linking Brian Dassey to the homicide was found in the house, unquote. The circuit court is incorrect about there being a small number of searches prior to the murder. For example, on September 18, 2005, there were 75 searches of violent child or underage pornography performed on the Dassey computer, obviously prior to Ms. Halbach's murder. Further, the circuit court's reference to Brian Dassey is perplexing and confusing. Brian was never linked to the murder in any way. In order to dismiss Mr. Avery's direct link between Bobby and Ms. Halbach's murder, the circuit court erroneously found that Ms. Halbach was murdered on October 31st, but there is no proof of when Ms. Halbach was murdered up until her remains were found on November 7th. The circuit court erroneously believed that Ms. Halbach's bones were found in Mr. Avery's burn barrel. No bones were found in Mr. Avery's burn barrel, but some of Ms. Halbach's larger bones were found in the Dassey burn barrel. In order to dismiss Mr. Avery's claim that Bobby had the opportunity to frame him, the circuit court relied upon a belief that every bone from Ms. Halbach's body was found in Mr. Avery's burn pit, and therefore Bobby could not have planted the bones in Avery's burn pit. Once again, this is a false fact, because it is undisputed that 40 to 60% of the bones comprising the complete skeleton of Ms. Halbach were never recovered. 40 to 60% never recovered. Again, 40 to 60% never recovered. The jury was unconvinced that Ms. Halbach was burned by Mr. Avery in his burn pit because he was acquitted of the mutilation of Ms. Halbach's body. Further, the circuit court relied upon Brendan Dassey's confession and its belief that Brendan was forensically linked to Ms. Halbach's murder to reject Mr. Avery's theory that Bobby framed him. Brendan's confession was not introduced into Mr. Avery's trial, and it is wholly improper for the circuit court to have factored the alleged confession into its analysis. Furthermore, Brendan was not forensically linked to the crime. Even if the circuit court's numerous factual errors were correct, and Brendan Dassey was, quote, directly linked by forensic evidence to this murder, unquote, and his confession was admissible evidence against Mr. Avery, this still does not allow the circuit court to dismiss the powerful evidence of a third party's direct connection to the murder. Overwhelming evidence against a defendant may not serve as the basis for excluding evidence of a third party's opportunity or direct connection to the crime. And now they're talking about other cases. The circuit court has ignored the strength of Mr. Avery's evidence and reached an illogical conclusion that which favors the state by misapplying the law and misrepresenting the facts. Conclusion. For the reasons stated herein, Mr. Avery respectfully requests that this court grant him one of the following alternative remedies. 1. Reverse the orders denying post-conviction relief and grant an evidentiary hearing. 2. Reverse the judgments of conviction and the orders denying post-conviction relief and remand for a new trial. 3. Grant any other relief this court deems appropriate. Dated this 13th day of February, 2024. And then it's form and length certification. I hereby certify that this brief conforms to the rules in section blah, 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 blah. The length of this brief is 10,841 words. So there you go. That is Kathleen's filing today that the state didn't like the one that she made previously because they said it was too long. And so this is the shortened version. But to simplify it, there is evidence the state or Manitowoc Sheriff's Department, whoever you want to blame and things for, stuff that they hid from Stephen's original attorneys. Sawinski contacted them on November, I'm so bad with these dates, November 4th? But Sawinski, whatever the date was that Sawinski contacted them, there's no making a murderer. There's no that this case is this big sensation that somebody would just be desperate to be a part of the case. That he reached out and contacted them, and there is audio proof of that. Kathleen has the call that then was covered up all these years. And Sawinski thought, well, I turned this in and they didn't get back to me, so they must not need me. And it isn't until years later when he watches Making a Murderer, he's like, holy cow, they don't have anything about what I saw in there. And then he reached out to the Innocence Project, thinking that was Stephen's attorney, and then Innocence Project doesn't turn that over to anybody. So that's pretty big to see Bobby with her vehicle. We know that they also blocked the coroner from being on the scene. And the coroner is the only person who legally can arrest the sheriff. Coroner outranks the sheriff. But they wouldn't let the coroner on that scene. The way they processed that scene in a coroner's absence, there's no pictures of the bones. We all know, we've watched a million things. You take pictures of the bones and then you put those little cards down that are numbered to flag everything. No pictures taken. And they claim it's because they were afraid of Bear, Stephen's German Shepherd that was chained up out there. You remove the dog. Because eventually they removed the dog. It's not like Bear was left there forever. Dog was removed. So you remove the dog. And then you take pictures. You don't touch and move anything until pictures are taken first. But you didn't take those. You wanted there to be porn on Steven's computer to try and prove that he was, this depraved guy. There wasn't any, but there is on Bobby's. Yet you want that dismissed. Barb tried to wipe that computer. That's dismissed. Bobby has scratches on his back. That's dismissed. Bobby brought home a deer that was found on the side of the road. That's dismissed. But again, if all those things, that Stephen was the person that did those things, it absolutely would have been used against him. Bottom line, reasonable doubt. There's absolutely reasonable doubt here. And, um, obviously my thoughts are Stephen should just be released and then now Wisconsin becomes Avery land. Because how do you pay back Stephen for all these years you've stolen from him and then you took his mom from him? Stephen can never be reunited with his mother in life. How do you put a dollar amount on that? Manitowoc has taken Stephen's whole life. You took him for Penny Bernstein that he didn't do, and he lost his wife and his children. Then he's only free for 2 years. Things are going well. He has a girlfriend he loves, and he's going to be coming into some money. And now you take that from him. And then his mom dies while, and the last year of his life, of her life, his corrupt family took Dolores from him and wouldn't let him talk to his mom while she was in hospice. So you don't know, nobody knows what the jury would have said if they knew all this information. So to say, oh, even if the jury had this, they would still have said guilty. You don't know that. You aren't that jury. So now we wait. We'll wait for the state to respond. And then I don't know how long then the court has to rule. I'll see if I can get Kathleen to give me the timeline on it, so I can I'll make a post and let you guys know what we're looking at there, because I never remember. And then as soon as we can get whatever the state files or what happens, I'll go live. It'll have to be at night because I work. Um, what happens if it's accepted, Brenna? We have to wait for what how the judge rules on what the judge is going to say on this. Is will it be an evidentiary hearing? Will it just be a whole new trial? So yeah, so the state gets to respond, and then I believe Kathleen gets to respond to that. So it's Kathleen, state, Kathleen. The state doesn't get to respond again. That and then waiting for the judge. So as soon as we hear anything, we go live as soon as I can. So if you see that somebody has filed or there's something out, you can always message it to Stephen Avery Project, because I'm at work all day, so I'm not following here. Christopher, the moderator, could get it before I do and let me know. And then when I'm off of work, I'll go live and go over it. I don't know at this point the next time I will be live talking about Stephen's case. Um, I may go live at some point next week to talk, but on Justice with Jax about Melissa Kaluzinski, because I'm going down to her prison on Monday to go to visit her. And then I also have stuff going in the Marnie Yang case, but we don't talk about those here. I do them on Justice with Jax. I just got something in the mail from Marnie Yang's daughter. Um, and we've got a court date for Marnie. Is it March 13th? I can't remember. And I'll be attending Marnie's court date. But again, that's all on Justice with Jax. But at least Melissa Kaluzinski, when I talk about her, she's also represented by Kathleen Zellner. But there's nothing going on in her case right now. I really wish there were. So, all right, I'm going to go because now it's almost 7 my time. I'm so starving for dinner. So, thank you everybody for joining me. Christopher would yell at me if I didn't do this before I go. A plug for my book that you can get on Amazon, Wrongfully Abused, Making an Advocate for Steven Avery. So this is on my experience with the case. I have another book I'd like to write in my head, but I've never sat down to start writing it. So you can get Wrongfully Abused on Amazon if you are so interested. Plug for me. Yay. All right. I'm out. Thank you, everybody. Investigation continues.